Once again, I'd like to thank my daughter, Sarah, for filming today. We're still in lockdown, so we're filming from home. Welcome, everyone. I'm Russell Alexander. We often cover family law matters and related topics from one of our office locations. However, in light of Ontario's state of emergency, we're coming from our home office. Our team continues to serve clients virtually to ensure safety of staff, clients, and the public. During the lockdown, we encourage everyone to stay at home and follow COVID-19 safety protocols. You can visit the COVID-19 Divorce and Information Center at russellalexander.com to learn more. Without further ado, let's get into today's topic: Court opines on impact of criminal bail conditions on families. In a recent criminal case called Khinda, the court urged that in cases of spousal violence and domestic assault, judges who set bail conditions should be sensitive to the overall impact they may have on the economic and emotional well-being of the other spouse, any children, and the family dynamic as a whole. Excuse me. The background facts involve spouses whose relationship had deteriorated. The wife had called the police over a number of incidents of violence by the husband, typically following an argument instigated by accusations that she had had a boyfriend. On 2 occasions, he slapped her in the face. In one occasion, he also bit her on the right shoulder and left hand. The wife also called 911 during an incident when the husband decided to wield a kitchen knife and threatened to kill her. He was charged with several offenses, including assault with a weapon and threatening. He was arrested and released on a promise to appear, in an undertaking requiring him, 1, not to communicate with his wife, and 2, not to attend at the family home. This necessitated his moving out. However, a month later, he and his wife were seen willingly together at a shopping mall for about 2 hours, which was confirmed on security cameras. The husband was arrested and charged with violation of his bail, which included a $5,000 surety release and further orders not to contact the wife or attend at the home. In a later bid to have the court amend the conditions of his bail, the wife filed materials in which she attempted to downplay the seriousness of the allegations and retracted some of them outright. She said that she relied on her husband for emotional and financial support and did not want to be a witness against him. She wanted him back home as soon as possible and was no longer afraid of him. Then, at the actual hearing before the court, she formally recanted all the allegations. In considering whether to vary the conditions of the husband's bail, as requested, the court began with these words: "The events in this case are all too familiar. The pattern is a well-worn one. The allegation of assault or threatening offense, the consequent bail order banishing the accused from the home and prohibiting contact, the ensuing hardship to the complainant wife, and then the recantation. This is a scenario acted out in domestic cases with alarming regularity. The wife said that many complainants in domestic assault cases say if she had known that her complaint would put this in motion, she would have never made it." The court continued, "The plight of complainants in these types of cases is a sympathetic one. They are in a vulnerable position. It could be said that they are between a rock and a hard place. There is a powerful financial and emotional pressure brought to bear on them as a result of the court-ordered separation. Generally speaking, there is strong incentive to reconcile with the accused. With that said, the court noted while the bail repercussions of the bail order were impacting both the wife and the accused husband in this case, the spousal assault scenarios, there is a contravening public interest ensuring that the complainant is protected from harm. Moreover, and this is from a noteworthy part from a family law context, the court indicated the damage wrought to the family unit, including children, cannot be ignored. If you are enjoying this video and find it helpful, you can give it a thumbs up or leave a comment in the box below. The court quoted at length from an older decision called Sshaw Bishop. Spouses of every walk of life, often with the completely unblemished prior character, are routinely detained for a formal bail hearing in such assaults. Invariably, the defendant, not yet convicted, is excluded from his or her home and prevented from exercising custody or access to the defendant's children with any consideration of the factors that this court must apply by law before determining incidents of custody or access. This is not for one moment to diminish the impact of spousal abuse on the family members and the children in Canada. Spousal assaults are by nature serious, and they are very sound policy reasons to lay such charges and have them proceed through the judicial system to an ultimate resolution, if not diverted. The court observed, however, that the damage of which the court speaks is not from laying of the charge. This will happen in any event, regardless of the manner in which the defendant is brought before the court. The way that the criminal justice system approaches commencement of these matters, however, often wreaks family law havoc with the family law unit of the dependent and the complainant, and in particular those of the children of those parties. Family courts decide custody and access issues on the basis of statute, case law, and the defining best interests of the children. The criminal justice system pays no attention to such interests because it is not geared up to do so. The court lamented that in these types of cases, where the conditions of bail imposed on accused spouse routinely include banishment from the home, with no allowance for the court to exercise its discretion, this was tantamount to an unthinking blanket policy. The court urged that criminal courts must instead exercise discretion in making these decisions in situations of domestic violence, while also cautioning that the discretion must be attuned to the seriousness of the contours of the problem, a serious problem by any estimation. The safety of the complainant must be paramount. With that said, on the particular facts of the case involving this husband and the wife, the court decided that it would be imprudent to relax the no contact provisions or rescind the husband's banishment from the home. The court stated quite often, despite the parties' expressed desire to reconcile, judicial paternalism is necessary. The complainant may not be fully able to appreciate the dangers ahead. Judicial experience plays an invaluable function in this context. Bail restrictions or pretrial detention may well be necessary to ensure that the complainant is adequately protected. To learn more about this case, you can read the full decision in the link in the description below. Please leave your thoughts and questions in the comment box below. If you liked this video and found it helpful, please give it a thumbs up to let us know. You can subscribe to our channel and hit the bell icon to get notification every time we upload a new video. Thank you for watching.